case is Poulos versus Poulos. Each party will have 15 minutes to present an argument. Now, this is a little different. We have appeals and cross appeals, but you will be expected to address each of the arguments, appeals, and the cross appeals at the same time during your argument time. The appellant may reserve up to 5 minutes for rebuttal. How long would you like to reserve?
I didn't hear you at the first time. I should address their brief as well.
You're not yet. Yes, please do.
Okay, I just want to, I'll probably use 5 to 7 minutes of my original 15. I'll reserve the rest for rebuttal.
Okay. The arguments are being recorded, so if we're doing that, number one, make sure you please come up and introduce yourself for the record. Secondly, please make sure you stay behind the podium. If you start to move, we'll lose you on the recording and maybe your voice as well. And then again, please speak loud so that the recording can pick you up. The judges have read your, exactly, if you're, in this case, I don't recall that there'll be a need to refer to children, but if you were to refer to a child or anyone of the victim, please do that by initials and not their full name, if you would, or an identification like the child. The judges have read your brief and are ready to proceed when you are.
Thank you, Your Honor. Good morning, Your Honors. My name is Denise Houston, and I represent Steve Poulos. It's an honor to be before you today in arguing our case, as well as addressing the appellee's cross appeal in this case. As I indicated, my intention is to only use about 5 to 7 minutes for my initial argument, and I will reserve the rest for my rebuttal. Also, as a housekeeping matter, Your Honors, I would like to just remind kindly everyone in the courtroom that there was a confidentiality settlement and release in this case that was addressed at the trial court level. It is marked as Court's Exhibit Number 1. As a result of not wanting to run afoul of the terms of that confidentiality agreement, it is my intention to refer to those involved, except for my client, in a more vague identifier. So instead of the actual name of the insurance company, I will reference the insurance company. Instead of saying the name of the case, I will indicate it as being the Florida case. And as to the other defendants, I will not use their proper names. I will just call them the sellers, if that's okay with everybody.
Yes.
Wonderful. Thank you, Your Honors. First of all, just to address our appeal, I have 7 assignments of error. My intention is to focus on just a small sliver of assignment of error number 3, and perhaps even a little bit of assignment of error number 1. Assignment of error number 3 has to do with the presumption of separate property under 3105.171. Assignment of error is a de facto issue. So starting off with assignment of error number 3, I just want to highlight to the court that there is a difference between a burden of proof on whether under 3105.171 versus the burden of proof on tracing something that has already been deemed a separate asset. And I think when you look at the cases, as I did coming back and reading my brief and preparing for today, sometimes those two are mixed up, or they are discussed in a lump sum, and that's inappropriate. So if you look at the statute, if an individual, if a spouse is compensated for a personal injury loss, there is a presumption that that is 100% separate property. The burden then shifts over to the other spouse to prove that part of that settlement is for lost wages, or it's to reimburse the marital estate for expenses that were paid in relation to the personal injury. In this case, when Mr. Poulos filed the lawsuit in Florida, he had 7 causes of action by the time his 5th amended complaint was accepted by the clerk. 3 of those were against the insurance company, all ringing in tort. There was fraudulent misrepresentation, negligent misrepresentation, and breach of fiduciary duty. And you noticed in my brief, I also compared both Florida law to Ohio law, as this case was in Florida, but you will see that the 2 states look at those causes of action the same. They ring in tort. Against the sellers, there were also 3 causes of action. One was fraudulent misrepresentation, breach of fiduciary duty was for the insurance company, I apologize. But there was a second fraudulent claim, and then also a breach of contract. Then there was 7th claim, which is vicarious liability, which encompassed all the defendants. So in this complaint, the majority of all of the claims were tort, which means they're personal injury, which means the damages are to compensate the plaintiff to make him whole by the tortious act of the defendants. There is nothing in there about a sale of the seller buying back the insurance company business that was sold to Mr. Poulos.
Was there any kind of settlement statement at the time, issued at the time?
Yes, Your Honor. In fact, if you go through the record, Court Exhibit Number 1 is the confidentiality agreement and the release. And then I believe quadruple N, as in Nancy, was also a distribution statement, not in the sense of breaking out the idea of how much was assigned from the sizable settlement to each of those accounts. But it does break down at least the amount of the settlement and then other aspects that were in the confidentiality agreement as far as liabilities that needed to be met, which was also part of the deal. So I want to make sure when I'm answering your question, I would call a triple or a quadruple N a settlement statement, but it is not a settlement statement to the extent that it says for count 1, X amount of dollars is assigned to that.
But you're saying there's some sort of delineation of what it was for? Is there?
I'm saying, sure, Your Honor, thank you for the question. I'm saying the majority of the causes of action are for torts, which means they're personal injury related, which means that a bulk of this very sizable amount, which I'm not going to reference to the amount, was based on and compensating him for personal injury claims.
Based on what the causes of action are? That's your...
Not only on the causes of action, but his attorney at the time of the settlement, Attorney Prosser, also testified that in Florida, asking for and being able to argue for punitive damages is not an automatic as it is here in Ohio. In Ohio, we plead punitive damages as one of our prayers for relief. In Florida, he had to go an extra mile and prove to that judge that the defendant, the insurance company, was grossly negligent before he was given the green light in order to even pursue punitive damages. Punitive damages are for torts, for personal injury. They are not for breach of contract. So when you look at the totality of the 7 causes of action, 6 being rooted in personal injury, 1 being rooted in breach of contract, you cannot come forward and say the totality of that settlement is going to be for something other than for personal injury, when the bulk of the claims are in fact for that.
Penny pointed out, I recall in the brief, that the tax return that came after was a claim that this was for a sale of a business or something to that effect. Would you concede that that's what the tax return showed?
I would concede that the tax return for Mr. Poulos' business does show a sale of the insurance company. However, and as I know from your background, Your Honor, we look at tax returns very differently in a domestic relations court than perhaps the IRS does. And for example, probably the most interesting and the easiest one to point out to this court is how does a domestic relation court consider depreciation? So for instance, if someone has a rental property and we look at their Schedule E, and Schedule E shows depreciation at the bottom of that overhead expense section, that's a paper write-off. It's not as though I write a check to somebody and give it to them for the amount of the appreciation. It's a fiction, but it's something that the IRS tax code allows people to take into consideration, which then reduces the amount of income that is then taxed. So in divorce court, we add that back in, and it's considered as income for support. Why? Because we know it's a fiction. It's something the IRS acknowledges and accepts, but in divorce court, it is not. I believe another example would be looking at someone's Schedule C if they are a private business owner. Those overhead expenses are in Schedule C. It is that individual's burden in divorce court to prove they're legit, to bring in your underlying documentation to show that if you had accounting fees of $1,500, that you have receipts to show that. We see the perhaps discrepancies come up in the more areas such as advertising, marketing, where you see someone put a dollar amount there. The attorneys are allowed to challenge the validity of that number, and if that number ends up not matching the underlying documentation, then you'll see the difference added back into income. So my position on that and their argument in their brief that the tax return is the holy grail in this and indicates everything, I would dispute that. It's not dispositive of the issue. You have to look at the totality of the circumstances. And I would even point to the case, Your Honors, that they relied upon, Moden versus Moden, that 9th District Court of Appeals case. The judges on that bench are no longer here, and I believe there was a mix-up in how they considered it. That was the case with the airline. The gentleman who was getting divorced 5 years after his airplane crash indicated that he felt the remaining amount that he could trace. So here's where that tracing issue starts overlapping with the presumption issue. But with remaining assets from his settlement, from the airplane crash, were his separate property. 2 months in the hospital, had pretty significant injuries in that case. In that case, wife did have a derivative claim of loss of consortium, which I know, Your Honor, you've done personal injury work, you know that's not uncommon. We have married individuals that, as practitioners, we will raise a loss of consortium. But at that point, there was nothing that indicated how much of his settlement was for his personal injuries versus his loss of consortium. At that time, Judge Quinlan indicated in his dissent that it is unfathomable for him to believe that not one penny of that settlement would be for his personal injuries, especially when you consider the degree. So I believe back in that time, when you look at the facts of that case, he recognized that even though the court may not have had a definitive line item for every cause of action, we cannot use our logic, we cannot lose our reason. We step back and we look at what are the totality of the claims. And in this case, there was never, as part of a prayer relief, an ask for the seller to purchase back the business. There was nothing like that. And the other thing I'd like to point out, and I'm just being cognizant of my time, is that if you look at Court's Exhibit number 1, and I'm not going to use the dollar amount because of this confidentiality agreement, but it is very easy to calculate that the insurance company's contribution to the totality of the settlement amount far exceeded that of the seller. The seller's contribution was a mere 4%. 4% of a sizable settlement. So to say that the entire amount somehow was not proven to be related to a personal injury or is not related, I don't believe that that's accurate, and I believe that the court lost its way. And in this, for my assignment of number 3, it is a manifest way to the evidence. That is the standard of review. I just noticed the time. I spoke longer than I wanted to, but obviously I want to address the brief very quickly. I do believe this is a final appealable order. The basis of their assignment of error, their sole assignment of error, is that they don't believe there's enough direction in the decree to advise the parties and their attorneys on how to divide the marital equity in the Del Rey condominium in Florida. I don't believe that's true at all. We can see the amount, and I know this one's a little contrary to my assignment of error number 2, because assignment of error number 2, I raised the issue of I believe that we cannot discern how the court figured out premarital versus marital in the conduct. But I'm going to argue if the court does not agree with my assignment of error, and we look at this, we obviously see how she calculated that premarital interest, how she determined the amount of the marital, she divided it in half, and everything, everyone had 30 days to divide the marital, go with the division of the marital property. Plenty of instruction there. Even if this court believes that my assignment of error number 2 has merit, there's still plenty of error. It's just that their brief and their assignment of error becomes moot because the case would have to be remanded back to the trial court in order for the trial court to determine what is the appropriate way to discern the value in Del Rey. And then also with all my other assignments of error, I'm asking for all of them to be remanded if this court agrees. So with that, Your Honor, I'll reserve the rest of my time for rebuttal.
Thank you.
Thank you.
Good morning, Your Honors. My name is Adam Morris on behalf of the appellee, cross appellant Anastasia Poulos. Your Honors, as Attorney Houston just provided her arguments regarding the settlement proceeds, I'm going to focus my first arguments also on that same issue. Your Honors, this was a business deal. It was flat out a business deal that went bad for her husband, and husband sued, and he sued under a number of different claims, business claims, breach of contract claims, interference of business operations claims. He went and hired a complex business litigation attorney, an attorney that had absolutely no experience in personal injury claims. His only experience was dealing with complex business issues. He came and testified. He testified at the trial. And at the trial, he testified that he's never dealt with personal injury claims. He testified that he had no knowledge about lost profits analysis. He testified that he was asked, would it be surprised, well, would it be difficult for Mr. Poulos engaging in the type of business he engages in to start another business after this 5-year litigation? He says, I have no idea. He had no idea about any kind of tortious claim that Mr. Poulos is now trying to claim after the fact. When they were in the litigation, and when they settled the litigation, and when they were paid, when he was paid the funds and reported on his tax returns, they treated this like a business claim, and he was paid back for. They treated it like a sale of a business. They treated it like that on his tax returns. So, Your Honors, this comes down to a credibility issue. Now, essentially 6-7 years after the fact, husband's coming in and now saying, no, this was all for loss of reputation, this was all for damages to me personally. This is a personal injury claim. But if you look at the facts that were occurring when they settled this lawsuit, and you listen to the testimony, you can see that this had nothing to do with a tort claim. This had nothing to do with personal injury. This had everything to do with settling these business claims.
The exhibit appellant refers to, NNN, I think she indicated, was kind of a settlement agreement. Does it give any kind of breakdown as far as what these are for, breach of contract, personal injury, any of the type of counts, as any of the defendants?
Your Honor, that's a great question, and no, it does not. It gives absolutely no breakdown of what this was paid for. But you can look at the counts. You can look at the issues that were in the complaint, and you can see it was for negligent misrepresentation. It was for breach of fiduciary duty. It was for fraudulent misrepresentation. It's for breach of contract, fraud in the inducement, and vicarious liability based upon agency theory. Those aren't personal injury claims.
But counsel, didn't he also, he pled for punitive damages, arguing intentional harm was inflicted upon him by the insurance company?
Yeah, he did plead for punitive damages, but there's no evidence that there was a breakout for any kind of punitive damages for personal injury claim. Okay, so there's nothing in the record to support that conclusion. And the judge, she had to take in the evidence, she had to weigh the credibility of Mr. Poulos, she had to weigh the credibility of Mr. Poulos' own business attorney, and she had to make a determination on whether or not she thought there was a personal injury component. And you can even look at Mr. Poulos' own testimony. If you go to page 2384, the question was asked of Mr. Poulos. So you didn't sue for intentional infliction of emotional distress, which would have arguably been a physical injury claim, correct? And his answer was, they refused to allow me to do that because it would detract from the fraudulent representation part. He admits in the record that this was not for a personal injury claim. Maybe he felt like he had a loss of reputation. That could be his own personal feelings. But when it came to the actual action, that's not what he was compensated for.
Did the trial court find that this was not separate property, or did the trial court find it was separate property, but it wasn't commingled?
No, the trial court found it was not separate property. The trial court found that this was marital property. And then if you look at the case law, Attorney Houston mentioned Moden v. Moden. That's a case that we mentioned in our brief. And you can see there, the court was very clear. There's arguments that there should be some sort of burden shifting. There's no burden shifting in the case law. Husband has the burden to prove that there was a personal injury component, and he has to be able to trace that personal injury component. And he is not able to do that, just like in Moden. There has to be, when you get one check, and you don't spell out, this was for personal injury, this was for, loss of, or this was for lost profits, this was for you know, maybe compensation for sale proceeds or funds that were put in the deal. He had the burden to trace that, and he couldn't. They cite to two other cases, which is Harrison v. Harrison. And the interesting in that case is the parties agreed and they stipulated that there was a separate property component and that could be traced. They cite to Mayor v. Mayor. And Mayor v. Mayor is a completely different case. This is a workers' compensation case. This is that's a personal injury claim. That's not like this case where it's a business lawsuit and now someone's trying to claim is a personal injury claim. So, Your Honors, we think that based upon the evidence that was in front of the trial court, the trial court had no other decision. They weighed the credibility, and the manifest weight of the evidence was that this was a business lawsuit. Husband worked on this. He used marital efforts on this. You can look at the record of all the time, the 10,000 hours he put into this case. He went through a number of different law firms. So Your Honor, we'd ask you that you would also agree with the trial court and find that was marital money.
So I just want to clarify. I want to make sure I understand what your position is. That there is no personal injury claim here. There's no evidence of it being a personal injury. So therefore, there's no presumption that kicks in, and the burden falls upon the other party to show that it was separate property.
Yes, I would agree with that. There's nothing that shifts the burden over to our client to somehow prove that the separate versus marital. I would argue that the appellant always has the burden to prove and trace the separate portion. I don't necessarily agree that there's some sort of burden shifting with separate property. I think when you have separate property, you have the burden as the proponent of that separate property to trace it, to prove it, and establish it for the court. You're going to the de facto termination. I want to talk about Tustin v. Tustin, which was brought up in the reply brief by the appellant. Tustin v. Tustin is a completely different case than this case. In that case, the parties separated in 2010. I think the appeal was actually heard in 2015. The parties were separated for a long portion of time prior to getting to the divorce. That case involved a civil protection order. The husband voluntarily left the house. This is a case where the parties, they filed a divorce, and then they essentially separated after they filed the divorce. This is no different than any other divorce case. If you could argue that this case was de facto termination, you could argue that any case is a de facto termination. This is not the case where the parties have been separated, they've separated their finances for a long period of time, and then they're coming to this court and they're filing the divorce action. Those are the classic de facto termination cases. This case would really broaden the scope for litigants to come in and argue for de facto termination because they separated after the divorce was filed, which is a typical divorce case. There are some of these issues I want to touch on, which are spousal support. Well, let me go back because I'm running out of time here. So let's talk about the Delray property. The court came up with a percentage, and the appellant is arguing that the court should have shown their exact calculation and the math for the calculation. And since the court didn't do that, it should not be. It should be reversed and sent back to the trial court. We disagree with that position. The trial court, based upon our calculation, we thought it could be 18% using a coverture fraction. We thought the court could use it. The court came up with 21%, which is actually better for appellant. So we would argue that there's harmless error here for appellant. But the court has to have some discretion on how they're coming up with numbers that are equitable. And putting this burden on the trial court to show every math equation for when they write a decision makes it almost impossible for the trial court. The trial court needs to have some discretion. I don't think anybody can argue what they did was not, that the judge did wasn't fair and equitable. Husband was not able to provide the mortgage balances as the date of marriage. He really couldn't provide a lot of information. And the trial court, gave him the benefit and actually tried to determine a separate property portion for him. And for now, him to come in and argue, well, the trial court didn't show me the calculation and they didn't do it right, even though the husband didn't provide the necessary information, I think that my client's position, that would be inappropriate. It really creates a very tough standard for the trial court and for the judge to attempt to, write a decision that's fair, just, and equitable. And in these cases, as the court knows, they're messy, right? And the trial courts are trying to do the best they can in making the trial court, show every single calculation they do is really going to extend litigation for the parties and for the litigants in the domestic relations court. They need finality, and sometimes everything is not perfect in decisions, as this court knows, but this decision was good enough, and it was fair, just, and equitable for the parties. I think I'm running out of time.
You have 2 minutes left.
Oh, okay.
Would you address the question about the personal property jewelry? It seems somewhat inconsistent to me to at one point say, this was kind of a conditional gift, I guess, of what you're saying. You had to stay married, and then the gift, if you didn't do that, the gift ended, and it would seem to me go back to separate property of the giver, yet the court seemed to order you have to pay money to this person and treat it as marital property. That seems inconsistent in the treatment of that.
Well, I think that the court was trying to do what the judge thought was fair. I think that her language in her decision is, I think that it's not exactly correct, but I think she was trying to get to the right answer. And that answer was that husband should get the jewelry back, but he should compensate wife for that jewelry. And I think she has the ability to do that. There's nothing that stops her from ordering husband to compensate wife for jewelry. There's nothing that stops her from...
Did she find with marital property specifically, do you recall?
I believe she found that it was husband's separate property. And then she ordered that he be reimbursed, that he reimburse her for the value of that. I don't necessarily agree with her reasoning. I think engagement ring is the gift is completed upon the marriage, but that's the decision that she came out with. I think once again that was for the benefit of husband. I mean, he got the benefit of that of getting that jewelry back.
So are those two ideas legally incompatible? The fact that you have a conditional intervitals gift and then you also have it, you have to compensate for that.
I would argue that they are not necessarily incompatible because the trial court has a lot of discretion on what she can do. I don't think that, I think that she has the ability to you could do a distributive award, you could do any kind of a number of things to do what she thinks is fair, just, and equitable. Like I said, every decision is not perfect. She tried her best, but we don't think that that's something that should cause this decision to be reversed.
Thank you, Mr. Morse. I know that you're out of time. You may briefly summarize if you wish.
Well, Your Honors, if you have any additional questions, I'm here to answer them. Thank you for your time here today.
Thank you. And you have likely more than 3 minutes left for rebuttal purposes.
I have 3 plus 5 or just, do I have
Well,
8 or-
but you went over your 5, so you have a 3-minute. You've already used 12 minutes of your 15 minutes. You have
Oh, okay.
3 minutes.
So I have a total of 3. perfect. Let me do rapid fire. To answer your question, Your Honor, yes, with the rings, her decision is incompatible, it's inconsistent, it is contrary. She found it to be a gift conditioned on them remaining married. If the condition fails, the gift fails, it goes back to him 100%. She made him buy it. So yes, it's inconsistent. It is an abuse of discretion. Number two, there is no such standard as good enough or trying her best. I want to point out that as being obvious. With respect to assignment of error number two, again, counsel kept saying her discretion. She should have discretion when considering the equity, whether marital, premarital, and Del Rey. That is not the standard of review for assignment of error number two. It's manifest way to the evidence. It is not abuse of discretion. With respect to Tustin, I find it interesting that counsel says
Did your
that...
client, on that issue, did your client provide sufficient evidence for the court to even determine what his separate property was at the time that they were married?
He provided evidence. Was it perfect? No, but it was there where you could calculate. When you can see a statement on a mortgage statement, and you can see what the balances are, and you can see how much goes to principal and how much goes to interest with each payment, that, if you extrapolate out, you can get an idea of the balance, which is what the
Prior,
judge
were you
did.
saying it all was separate, or what were you saying the division should be between separate and married?
Yeah, so Del Rey is a combination of my assignment of error number two and number four, because, he testified and the trial court agreed that during the course of the marriage, he did nothing active to increase the appreciation of the marriage, of the value of that asset during the course of the marriage. So when you look at it, you had, what was it worth the time they got married? He bought it, I believe, 5 years before. What was it worth? What's the mortgage? What was it worth at the time of marriage? What was it worth at the time that it was valued for purposes of the divorce case? You can look at, is the equity that accumulated by pure market forces, was there equity that also accumulated by paying down the mortgage? But the coupling to assignment of error number four is not only do we have that issue, but Del Rey gets a little more complicated in the fact that after we believe would be considered a de facto termination date, he then used what we believe to be separate funds, which stemmed from the insurance company settlement from Florida case, and use that to make improvements. So if you find and agree with me on assignment of error number three, that those funds are his separate property, and you agree there's a de facto date that is sooner than what the court used, which was the first day of trial in May of 2022, I believe, then his use of those funds to make the improvements to Del Rey would also then be his separate property. I know it's confusing. This is an 11-day trial, and there's like 3,000 pages of transcript, so I get that. Your Honor, to circle back on Tustin, I think what is interesting is, in my response, my reply brief, I pointed out how reminiscent Tustin is to what actually happened here. The parties started this lawsuit with White filing a complaint September 28th of 2020, December of 2020, first temporary orders go on. Interestingly enough, the house was a substantially sized
And I'll
house.
help you out of your vote.
Oh, okay, thank you. Sure, I'll just rely upon my brief for the rest. I think I adequately covered it, and you can read it and see why I hotly dispute what they have argued during their oral argument. Thank you, Your Honor.
Thank you, and thank you both for your presentation today. The court will take the matter under advisement and issue a decision in due course. The clerk of court will mail that decision to you, not us personally, and the opinion will also be released on the Supreme Court website. At this point, we adjourn.